My name's Charles Lyon. I'm a partner in the IP group here at Choate, Hall & Stewart.
And my name's Marandett. I'm a partner in the IP litigation group here at Choate.
So what we wanted to talk about today is the handling of information in the context of a due diligence and kind of how to best manage that and avoid some potential unintended consequences when it's poorly managed.
Yeah, I mean, one of the key issues that often comes up in diligence is when an acquiring party is looking for information that actually is trade secret or attorney-client privilege. And there's real demand to get the information because it's relevant to the assessment of the company's value, but there's risks associated with that, and there's some strategies to manage that risk that we've seen and found to be effective.
Yeah. And maybe to give a concrete example, I mean, one situation that comes up pretty often, particularly maybe when an investor is looking at making an investment in a company and they're aware that the company may have an opinion of counsel with respect to some particular third-party patents, and there may be some concerns around freedom to operate, and they think it's going to be efficient and expedient to get hold of that opinion just because it's there and it will save time, but there's a real risk there with privilege.
Yeah, the problem with that is once the opinion itself is turned over, that's a waiver of privilege, and if there's subsequent litigation, particularly if the deal gets done, that waiver could cause the disclosure of much more than that opinion itself. So the question is, how do you get that kind of information and analysis to the acquiring party without actually waiving the privilege? And there's ways to do that.
And typically, I mean, the one step to take is to minimize written communications, maximize the amount of transfer that can be done orally, working with counsel, so the counsel is speaking to counsel on both sides as opposed to having the two companies speaking directly.
Yeah, and limit the disclosure to just the facts, not the opinion itself. I mean, particularly when you're working with counsel, counsel can speak to each other, say, here's an issue you need to look at, here are the facts you need to look at, and that leads them to the result that they need in terms of getting at the legal analysis without actually seeing the opinion itself.
Yeah, and that brings up another example is, often maybe you're the company's, you're the investor wanting to make an investment and you've done some analysis, identified some third-party patents, and you want to have a discussion maybe about these patents with the company. Rather than talking about the patents, you can come up with some technical, factual questions that will help you make an independent analysis of those patents, and again avoid talking about legal issues and disclosing legal opinions.
And the company can point you to particular patents of interest and pieces of patents of interest without actually giving the legal conclusions, but by doing that can lead you to the information you need. Sort of a second area that often comes up that's of concern is the disclosure of trade secret information, particularly when trade secrets are a key value driver for the company. And again, there's often resistance to turning that information over in diligence, but it can be managed provided appropriate restrictions are put in place to maintain trade secret status.
So maybe to wrap up, I think one of these are important issues that everyone needs to pay attention to, but there are certainly issues that can be managed.
Yeah, I think that's exactly right. I mean, the key is that there are ways to manage these issues, and they shouldn't be impediments to deals. And we hope that's the kind of thing that you find helpful.